What does it mean when the most dangerous threat facing a community is one that cannot be seen, that arrives silently through the water, accumulates in bodies over years, and is understood only after the damage has already been done? In a small desert town in California in the 1990s, a single mother with no formal legal education, working as a file clerk in a small law firm, began noticing inconsistencies in medical records attached to real estate files, and refused to stop asking questions until she understood what they meant. Tonight, I am here with Ron Hartsteele.
Good evening, Clara.
The story of Erin Brockovich is often told as a story of individual triumph, of one determined woman against a powerful corporation. It is that, but it is also a story about how truth works, how it does not disappear when it is suppressed, but accumulates pressure, how it is often found, not by experts, but by people who refuse to accept incomplete explanations. How the most dangerous knowledge is the kind that someone has deliberately kept from reaching the people it most affects. Tonight, we turn to a case that revealed how invisible harm can be, how long it can remain invisible when those who caused it have an interest in that invisibility, and what it takes to force it into the open. The question is not simply what happened in Hinckley, California. The question is what the Hinckley case reveals about how environmental harm accumulates, how institutional knowledge operates when it is in tension with institutional interest, and how many similar cases remain undiscovered because no one has yet refused to accept the incomplete explanation.
The most dangerous truth is not the one that is loudly denied. It is the one that is quietly not mentioned, the pattern that is visible in aggregate, but invisible in any single case. The harm that accumulates over years, in ways that no individual doctor's visit or water quality report fully captures. The Hinckley case is a precise demonstration of how that kind of truth works, and of what it takes to reconstruct it.
We are speaking about the Hinckley groundwater contamination case, the investigation conducted by Erin Brockovich and the law firm of Masry and Vidito, and the $333 million settlement reached against Pacific Gas and Electric in 1996.
At the time it was reached, it was the largest settlement ever paid in a direct action lawsuit in United States history. But the number matters less than what it represented. A formal acknowledgement that a major corporation had knowingly contaminated the water supply of a community, and had not ensured that the people most affected had the information they needed to protect themselves.
Then let us begin with the town, and with what made it so ordinary, which is part of what made what was happening there so difficult to see.
Hinckley is a small unincorporated community in the Mojave Desert in San Bernardino County, California. In the 1960s, Pacific Gas and Electric established a compressor station there as part of a natural gas pipeline system. The station compressed natural gas for transmission across California, a routine industrial operation. To prevent rust in the cooling towers, the facility used a chemical called hexavalent chromium, also known as chromium-6. Hexavalent chromium is a highly toxic compound. It is a known carcinogen in humans. When wastewater containing hexavalent chromium was discharged into unlined ponds at the Hinckley facility, the chemical migrated into the groundwater beneath the surrounding area. The contamination spread gradually, invisibly, through the aquifer that supplied water to local residents. People were drinking, bathing, and cooking with contaminated water for years without knowing it.
So the harm was entering people's homes through the most basic and trusted infrastructure of daily life.
Yes. And here is the first thing we need to correct about the standard account. The story is often told primarily as a story about Erin Brockovich's determination and personality. These are real and important, but the more significant aspect is the structural condition that made the case possible. The fact that information about the contamination and its health risks existed within Pacific Gas and Electric's own internal records, that some of this information had been shared selectively with regulators, and that the residents of Hinckley had not been clearly and fully informed of the risks they faced. Erin Brockovich was born in 1960 in Lawrence, Kansas. She had 3 children from 2 marriages, had struggled financially, and had no formal legal training when she began working as a file clerk at the Masry and Vitito law firm in Thousand Oaks, California in the early 1990s. She had previously worked in a series of jobs and had been involved in a personal injury case that had brought her into contact with the firm. While organizing a real estate file related to a property in Hinckley, she noticed that it contained medical records. Medical records in a real estate file were unusual. She began asking questions about why they were there and what they contained. The records showed that the property owner had been experiencing significant health problems. Pursuing the connection, Erin began visiting Hinckley, speaking directly with residents and discovering that serious health problems were widespread in the community.
So the investigation began with a single anomaly, a file that most people would have filed without reading.
Yes, and this is one of the most instructive aspects of the case. The discovery did not begin with a tip or a leaked document or an investigative journalist with a theory. It began with someone noticing that something in a file did not belong there, asking why it was there, and following that question rather than setting it aside. The investigation was built from attention to small inconsistencies rather than from the application of expertise. What Erin found in Hinckley was a pattern that was invisible in any single case but unmistakable in aggregate. Residents were experiencing cancers, tumors, miscarriages, immune disorders, and other serious conditions at rates that made no sense for a small desert community. Each individual case could be explained separately. Taken together, they formed a picture that demanded an explanation. The common element was the water. Erin's method of building trust with the residents was essential to the case. She went door to door, listened to people's stories without judgment, remembered the names of their children, and consistently demonstrated that she was genuinely invested in understanding what had happened to them, rather than simply gathering information for a legal file. In a community where institutional responses had been inadequate or dismissive, this personal engagement created the trust that made residents willing to participate in the legal action.
So the human connection she built was not incidental to the legal case.
Yes. The legal case eventually identified over 630 plaintiffs, residents of Hinckley and surrounding areas, who had been harmed by the contamination. The number itself was a demonstration of the systemic nature of the harm. This was not one family affected by unusual circumstances. It was an entire community experiencing elevated rates of severe illness because of what was in the water that served them all. The critical turning point in the case was the discovery of internal Pacific gas and electric documents indicating that the company had been aware of the health risks associated with hexavalent chromium contamination in the Hinckley area for years before the lawsuit was filed. Documents showed that the company had conducted its own studies, had corresponded with state regulators, and had information about the extent and duration of the contamination. The question of what the company had known, and when it had known it, became central to the case.
So there was a gap between what the company knew internally and what the affected residents had been told.
Yes, and this gap between institutional knowledge and public disclosure is one of the central ethical problems the case raises. Whether the gap resulted from deliberate concealment, from inadequate communication systems, or from a series of decisions in which no single person felt fully responsible for ensuring that residents had complete information, the practical effect was the same. People who needed to know what was in their water in order to make informed decisions about their health and their children's health did not have that information. The health effects of hexavalent chromium exposure are worth explaining in some detail, because the invisibility of the harm is central to understanding why it persisted so long. Hexavalent chromium is classified as a Group 1 carcinogen by the International Agency for Research on Cancer, meaning there is sufficient evidence that it causes cancer in humans. The primary route of concern in the Hinckley case was ingestion through drinking water. Long-term ingestion of hexavalent chromium has been associated with increased risk of stomach cancer, liver damage, kidney damage, and reproductive effects. These consequences develop over years or decades. The connection between the exposure and the illness is not visible to the person being harmed.
So a person can be consuming a carcinogen daily for years without any immediate signal that anything is wrong.
Yes. And this delayed effect is what makes this category of environmental harm so difficult to address through normal market or legal mechanisms. The harm does not produce an immediate signal that would trigger a normal protective response. By the time the signal arrives in the form of elevated cancer rates or other health problems, the exposure has been occurring for a long time, and the causal chain is difficult to establish to the satisfaction of legal standards in seas. The role of the law firm of Masri and Vitito in the case requires acknowledgement. Ed Masri, the attorney who supervised the case, was willing to pursue it despite the cost and risk involved in taking on a major utility company with extensive legal resources. The case required expert testimony, extensive document review, and the management of over 600 individual client relationships. The decision to pursue it was not self-evidently rational from a pure business perspective, and the willingness to commit the firm's resources to it over several years was itself a significant element of why it succeeded.
So the institutional support?
Yes. Persistence and attention without institutional backing have limits. The Hinckley case succeeded because individual determination was combined with access to legal expertise, the resources to gather evidence, and the willingness of a law firm to commit to a difficult and expensive fight. People in affected communities who lack access to any of these elements face considerably higher barriers to achieving similar outcomes. The way Pacific Gas and Electric responded to the litigation also reflects a pattern familiar from other large corporate liability cases. The company had significantly more legal resources than the plaintiffs. It could deploy teams of lawyers, expert witnesses, and technical consultants who could challenge the causal claims being made. The asymmetry of resources between a corporation defending a liability claim and a community of affected individuals making that claim is a structural feature of how such cases are litigated, and it systematically favors the defendant.
So even when the underlying facts strongly support the plaintiffs, the legal battle is structurally uneven.
Yes, the Hinckley settlement was reached through binding arbitration rather than a jury trial, partly because the number of plaintiffs and the complexity of the evidence made a trial impractical. This meant that the detailed factual record of the case was never fully established in a public legal proceeding. The settlement resolved the claims without creating the kind of public precedent that a full trial might have produced. This is another way in which large corporate liability cases can be resolved in ways that limit the broader systemic accountability that might otherwise follow.
Before we close tonight, let us take a brief pause and welcome Margaret Evernight. Margaret, for those who want to understand the case from the inside, from the perspective of the person who pursued it, where would you invite them to continue?
Thank you, Clara. In this case, the most direct path is also the most important one. I would suggest beginning with Erin Brockovich, Superhero, by Erin Brockovich herself.
So this is a first-person account of the investigation, written by the person who conducted it.
Brockovich provides a personal account of the investigation that exposed one of the largest environmental contamination cases in the United States. The book offers insight into how the case developed, the resistance faced along the way, and the human impact behind the legal battle. It conveys not only the facts of the case, but the experience of pursuing it from the position of someone without institutional authority or formal credentials.
Is it accessible to readers without a legal or scientific background?
Brockovich writes directly and without technical complexity. The book is primarily a narrative of discovery and persistence, rather than a legal or scientific analysis. A reader with no prior knowledge of environmental law or chemistry will follow it without difficulty and will likely find its account of the human dimension of the case more affecting than a more technically oriented account would be.
So it gives the reader the inside experience of what it actually takes to pursue a case of this kind against an adversary of this size.
Precisely. And the book also reflects on the broader pattern of environmental harm she has continued to encounter and document since the Hinckley case, which reinforces the argument that Hinckley was not an isolated incident but an example of a recurring structural problem.
Thank you, Margaret. That is a thoughtful place to pause tonight.
Thank you, Clara. It was a pleasure.
The settlement reached in 1996 was $333 million, distributed among the more than 600 plaintiffs. At the time, it was the largest settlement ever paid in a direct action lawsuit in American history. Pacific Gas and Electric did not admit liability as part of the settlement. The company subsequently undertook remediation efforts in the Hinckley area. Though the effectiveness of those efforts and the continuing levels of contamination in the area have been subjects of ongoing investigation and dispute, the settlement was a significant legal outcome. It was not a restoration. The health consequences experienced by Hinckley residents over the preceding decades could not be undone by a financial payment. The cancers that had been treated, the miscarriages that had occurred, the years of illness and uncertainty, none of this could be reversed. The settlement was a partial correction of damage that could not be fully corrected.
So the outcome acknowledged the harm without being able to undo it.
Yes, and this is one of the persistent features of environmental harm cases. The legal system can establish accountability and provide compensation. It cannot restore health that has been lost, reverse exposure that has already occurred, or give back the years in which people lived without knowing that what they were drinking was poisoning them. The scale of the settlement reflected the scale of the harm. It did not eliminate the harm, The question the Hinckley case raises about how many similar situations exist is not rhetorical. Studies of environmental contamination cases consistently find that the identifying of harm depends heavily on whether someone with the persistence and the access to connect patterns across individual cases happens to be present. The conditions that allowed Hinckley to be exposed are not reliably present in every place where comparable harm is occurring.
Zoe Hinckley becoming visible depended on a specific combination of circumstances that do not exist everywhere a comparable situation exists.
Yes, the health effects of long-term low-level exposure to hexavalent chromium in drinking water continue to be studied. Subsequent monitoring in the Hinckley area found that contamination levels in parts of the plume had increased in the years after the settlement, partly because natural processes were mobilizing chromium from soil into groundwater. The broader legacy of the case extended into regulatory policy. None. The Safe Drinking Water Act and Environmental Protection Agency standards for hexavalent chromium in drinking water were the subject of extended regulatory debate in the years following the Hinckley case. California eventually set its own standard for hexavalent chromium in drinking water, though the process of setting that standard involved considerable scientific and political dispute. The case contributed to a national conversation about the appropriate regulation of a specific chemical that it had not previously received.
So the case changed not only what happened in Hinckley, but how the country thought about the specific substance that had caused the harm.
Yes, the philosophical conclusion the case most clearly supports is that truth does not disappear when it is suppressed or ignored. It accumulates pressure. Contamination in Hinckley was real from the moment it began. The harm it caused was real from the moment the first resident drank the water. The knowledge within Pacific Gas and Electric's records was real from the moment it was documented. None of this reality was changed by the fact that it was not visible to the people most affected. It simply waited, in the bodies of 600 people, until someone refused to accept the incomplete explanation. The secondary conclusion is equally important. Expertise is not the only path to understanding. Erin Brockovich had no formal legal training, no scientific background in toxicology or hydrology, no credentials that would have given her authority in the settings where this case was ultimately decided. What she had was attention, persistence, the ability to listen to people and connect their individual experiences into a pattern, and the refusal to accept that an anomaly in a file was not worth understanding. These capacities are not the exclusive property of any particular educational background.
So the case is also an argument about who gets to notice things that matter.
Yes, and the answer the case provides is anyone who pays attention and refuses to accept incomplete explanations. The problem is that paying attention and refusing to accept incomplete explanations requires time, access, and the willingness to pursue a question that many people in positions of authority would prefer not to be asked. Those conditions are not equally available to everyone. The Hinckley case succeeded because a specific person with specific characteristics was in a specific position. That combination is not guaranteed anywhere else.
Thank you for staying with us tonight. And thank you, Rowan, for guiding us through the ordinary-looking town, the medical records in a real estate file, the 600 people whose individual cases became visible only when someone connected them. Truth that had been waiting in the water all along.
The Hinckley case reminds us that truth does not require permission to exist. It only requires someone who notices the anomaly, asks the question, and refuses to stop until the answer makes sense.
If this conversation stayed with you, you are welcome to like, comment, and subscribe. You will find other episodes here, where history, ideas, and power are approached slowly. Until next time, stay with us.